The most effective way to destroy a people is to deny and obliterate their understanding of their own history. George Orwell. As you can tell from the title of this video is going to be about James Madison. Specifically, it is going to be about how James Madison conned the free and independent states into ratifying the United States Constitution. Yes, believe it or not, the architect of our current Bill of Rights, James Madison, is a liar and a con man, and he is not the true architect of the Bill of Rights. He is actually a plagiarist, and as I said before, a con artist who made sure that the American people would have a substandard Bill of Rights. So in order to understand why I'm levying these accusations against James Madison, we have to first look into a couple of nuances, a couple of little details. We have to know that he is hailed as the father of the Constitution. That's very important because he created the Constitution without a Bill of Rights. And by that I am talking about the original draft of the Constitution. He drafted the Constitution without a Bill of Rights. And this is why the Bill of Rights was amended to the Constitution, meaning it came after. Which brings me to the next important detail, which is how long after his original draft of the Bill of Rights did James Madison introduce the Bill of Rights that we know today? And we can find that answer in a lot of places, but I'm going to use this article from the National Constitution Center, or nationalconstitution.org, or something like that. I'm pretty sure that's the website you can find it on. And this article is entitled 5 Items Congress Deleted from Madison's Original Bill of Rights. And I'll share with you why I'm using this article in a second. It's because this article has other details that we need to know. So, in this article, according to this article, in the end, many of the core ideas introduced by Madison in June 1789 made it into the ratified version of the Bill of Rights. So, this article is letting us know that Madison introduced his Bill of Rights in June of 1789. And for those of you who do not know, soon you will know, the Constitution was first drafted and presented in 1787. So, 2 full years afterwards is when Madison introduced his Bill of Rights. Now we're going to look at one more detail before we look into why it took Madison 2 whole years to introduce his Bill of Rights. And this is why I chose this article. So this article, remember from the title, as we can tell, it's the items that Congress deleted from Madison's original Bill of Rights. Well, this article lets us know that there were some very significant deletions as his proposed list went through the House of Senate, and Madison himself took part in the decisions to edit out some of his own ideas. So that's the incredible thing that I like about this article, is it talks about how actually Madison himself had a hand in editing out portions of his Bill of Rights. Another thing that I find funny about this sentence, which can be found in this article, is it makes it as if these were his own ideas. It's rather brilliant, the kind of propaganda that's presented here. So right now, I'm going to show you how the Bill of Rights was not Madison's idea, nor were any of the rights that he presented, nor any of the points that he presented, none of them were his, actually. And I'm also going to go into why he actually played a hand in creating the Bill of Rights and then editing parts of the Bill of Rights out. Okay, so strap yourselves in because this will definitely end with a major conspiracy. But first, there are more facts and more subtle details that we must go over. Starting from the drafting and the signing, or starting with the drafting of the Constitution. Okay, so in 1787 is, as I said before, when the Constitution was being drafted and when all of that hocus pocus was going on. So there's just a couple things that I want to mention here. So this is from Wikipedia. What you do is go to timeline of ratification of the Constitution, and you can find out all of this. Okay, so I'm gonna skip to 1787, September 17th. Everything before this is just pretty much minor details of of why these people were even getting together in the first place, how they were actually supposed to get together to make changes to the current Constitution, the Articles of Confederation. They actually weren't meant to create a new constitution. So there's a lot of other subtle dates and subtle details. So this is just something I want to point out the dates from this point on. So September 17th, Constitution signed and convention adjourned. the convention is the Constitutional Convention in which this Constitution was drafted. So there's just a little subtle detail I want to point people towards. So that is, the approved Constitution is signed by 39 delegates from 12 states, all but Rhode Island. One delegate, John Dickinson, who was ill and not present, had George Read sign his name by proxy. That's not very important. This next point is important. So it is 3 delegates present declined to sign the document: Edmund Randolph, George Mason, a very great man, and Elbridge Gerry. These are all guys that you guys should look into. You should read their paper, you should read their work, and you should look into why they didn't sign this document. And I actually talk about George Mason in my anti-federalist videos. So anyway, everything else is just kind of like, not necessary. That's pretty much just like the point I want to make from September 17th. So anyway, so the convention is adjourned September 17th, okay? So now if you look down at the very bottom there, September 27th, 10 days later. So 10 days later, the first anti-federalist paper came out, okay? The first anti-federalist letter by Cato is published, okay? And the anti-federalist are papers that you guys have to read. They're all pretty much arguments against the Constitution and against this federalized state that we have, this strong centralized government. So Anti-Federalist paper came out on September 27th. Anti-Federalist paper came out on October 5th. Anti-Federalist paper came out October 8th. Anti-Federalist paper came out October 18th. You had a whole series of Anti-Federalist papers. So then finally, a whole month later, remember the first one on September 27th, a whole month later, the sophists finally managed to put together their first paper. And here's what it says. October 27th is the first Federalist paper. And it says here, first of the Federalist papers, Publius, Federalist number 1, is published in the Independent Journal. And it's the planned series of essays would, the authors hoped, give a satisfactory answer to all the anti-Federalist objections which shall have made their appearance that may seem to have any claim to your attention. That's just like, you can tell just from that quote right there, give a satisfactory answer to all the anti-federalist objections which shall have made their appearance that may seem to have any claim to your attention. That in itself is just like total double speak. It's just like, what are they saying here? The objections that may have seemed to have any claim to your attention. Like, okay, so I'll just let you guys in on a little secret here, okay? You can read these Federalist papers, and if you read them critically enough, you'll see that they're nothing but sophistry. Nothing but sophistry and propaganda. And many of these Federalist papers were put together by Alexander Hamilton, the greatest sophist of them all, and yours truly, James Madison, okay? I've read these Federalist papers. Thank God I had an English class, which we had to read the Federalist papers, or at least the essential Federalist papers, because without that class, I wouldn't have come across any of this. This is one of the good things about going to college, is that you are introduced with information that you would more than likely not have stumbled upon yourself. So if you read those papers, you'll see exactly what kind of sophist these people were, especially Alexander Hamilton. I'm actually going to make another video in one of my anti-federalist videos, or maybe just a video specifically about how Alexander Hamilton was a sophist. I'm going to show you some of the shit that he has the nerve to write in those papers, okay? The dude was a sophist of the highest order. He actually reminds me of the social justice warriors and the political sophists of today. They must have actually been schooled directly by him. It's incredible. But I digress. Let me get back to the point. And that point was that these Federalist papers were just works of sophistry. They were actually propaganda that greatly influenced the ratifying process of the Constitution. Of course, there was other propaganda. The Federalist papers were actually just minor propaganda. There was way more extreme propaganda going on in the actual newspapers and stuff. So, moving past that point, now getting to the ratification process. So the ratification process started at the end of 1787. But I'm going to skip the first 3 states that ratified, because the first 3 states that ratified with no objection. Actually, so did the 4th and the 5th state. So the first 5 states that ratified the Constitution with no objections whatsoever. So if we see here, though, February 6th, the ratifying in Massachusetts. So it started actually on January 9th and then concluded on January 6th. Massachusetts becomes the 6th state to ratify the Constitution, 187 to 168. That's a very close margin. And the reason why they even ratified is because, as you can see here, in addition to ratifying the Constitution, Massachusetts requests that 19 alterations be made to it, to the Constitution. Here, it basically, we can actually conclude, and we're gonna actually see evidence of this, that the only reason why the ratification was approved in Massachusetts is because a lot of people were swayed by making them believe that the Constitution would be altered. They were led to believe that, like, basically they were saying, okay, we're going to ratify, but we're going to ratify under this condition that some alterations be made. Okay, and we're going to find evidence of this later on in this video. So you see how close that margin is, okay? Trust me, if these people were told that, oh, no, these alterations, especially 19 of them, they're not going to happen. And the ones that are going to happen, they're going to be mediocre at best. They're actually going to be totally substandard. They would not have ratified in Massachusetts, okay? Very close there, 187 to 168. So now we're going to look at other states that requested alterations. Okay, so first we're going to look at Rhode Island. Rhode Island, and this is going to be very interesting here when you see what happens to Rhode Island. Rhode Island decided that they were going to have a popular referendum on the proposed Constitution. And check this out. So voters in Rhode Island voted down the Constitution 2,708 to 237. That is like a major defeat on the Constitution there. But you're going to see later on in this video how they managed to basically pull one over on the people of Rhode Island. It's really, really sad. So then April 10th of 1788, an Albany Anti-Federalist Committee published a circular forcefully objecting to the proposed Constitution, calling the frame of government more arbitrary and despotic than that of Great Britain. And I'm going to go over this in another video. I'm going to make a video about how the Declaration of Independence, the Independence Revolution, only lasted about 12 and a half years, and how the Independence Revolution was ended with the ratifying of the U.S. Constitution. I'm going to go into how the U.S. Constitution is not conducive, or it's not compatible, and actually violates the Declaration of Independence. And these people, the Anti-Federalists, they knew it was, and they were calling it how it was. So going on to South Carolina now. So we're in 1788, May 23rd, 1788. South Carolina becomes the 8th state to ratify the Constitution. Remember, we're going to jump around because I'm trying to cover the ones who were ratifying the Constitution with the request that alterations be made to the Constitution. Okay, this is actually what really influenced the creating of the Bill of Rights, is the fact that there were states who were proposing these alterations, who were proposing these amendments to the Constitution. And not even amendments. They wanted it to be like the Constitution, the main body. They wanted it to be actually threaded in to the main body. They didn't want amendments. They wanted actual alterations to take place within the main body of the Constitution, okay? So South Carolina. In addition to ratifying, South Carolina requested only 2. They just wanted 2 alterations, okay? So, South Carolina, it was 149 to 73 it passed, okay? With the requesting of 2 alterations, okay? So moving on to New Hampshire. New Hampshire was another close one. They became the 9th state to ratify the Constitution, 57 to 47. In addition to ratifying the Constitution, New Hampshire requested that 12 alterations be made to it. Once again, that's a pretty close margin. That's a margin of 10, 57 to 47. We need to ask ourselves, would they have actually ratified it if they knew that these alterations wouldn't take place, or if these alterations would take place on a substandard level? So moving on now. Virginia becomes the 10th state to ratify the Constitution, 89 to 79, another very close margin. In addition to ratifying the Constitution, Virginia requests that 20 alterations be made to it, okay? 20 alterations. Once again, I'm going to say it again. If these people knew that these alterations would not take place or would take place on a substandard level, would they have ratified the Constitution? I don't believe they would have. Okay, moving on. So, first ratifying convention held in North Carolina. With the hope of effecting the incorporation of a Bill of Rights into the frame of government, delegates voted 184 to 84 neither to ratify nor to reject the Constitution. So essentially in North Carolina, they were just voting to say, hey, look, we're not going to accept it, we're not going to deny it. Instead, we're just going to say that we'll take it if you guys can incorporate a Bill of Rights into the frame of government, not amended to it, into the actual frame, into the actual body of the Constitution. They want to actually be interwoven into the main body of the Constitution. Okay, because there is a difference between the main body and then things that are amended to the main body. Okay, so now we're going to go on. So New York becomes the 11th state to ratify the Constitution, 30 to 27. Damn, that's a really close margin. Okay, in addition to ratifying the Constitution, New York requests that 33 alterations be made to it. 33. Okay, once again, I have to say it again. Would they have ratified the Constitution if they knew that most of these alterations would not take place or would take place on a substandard level? We have to ask ourselves that, okay? Because this is the con that James Madison was actually pulling on them. Okay, he was actually convincing them that yes, we'll make some alterations. Maybe we'll do that. Don't worry. So moving on now. So November 21st, 1789. Actually, I'm sorry. Before we move on, we have to remember that this is July 26th. New York does it in 1788. And then like a whole year and what is that? July, August, September, October, November, like a whole year and 4 months, whole year, 3 months. In 1789, North Carolina becomes the 12th state to ratify the Constitution. Okay, this is November 21st of 1789. Now remember, in June of 1789 is when James Madison introduces the Bill of Rights. Okay, so even at this point in November of 1789, North Carolina becomes the 12th state to ratify the Constitution, 194 to 77. In addition to ratifying the Constitution, North Carolina requests that 26 alterations be made to it. These are a lot of alterations that they want to be made to it because there's a lot of things wrong with the U.S. Constitution. And the same thing goes for them. Would they have ratified if they knew what was actually going to be done? Okay, so 1790. Here we go back to Rhode Island. Now, just watch how they screwed over Rhode Island. Remember, the last time that Rhode Island voted for the Constitution, it was with a popular referendum. This time, though, in May of 1790, they decide to not do a popular referendum. And what happens? Rhode Island becomes the 13th and final state to ratify the Constitution. 34 to 32. How close of a margin is that? Seriously, remember what they voted before, okay? They voted like 2,000 plus to less than 300. Okay, before it was a landslide defeat for the Constitution, so that's exactly why they had to change it and say, okay, look, we can't do a popular referendum. We're gonna do this representative thing, and we're gonna make these people decide. And in that case, it's just a pinch close. And then what happens? In addition to ratifying the Constitution, Rhode Island requests that 21 alterations be made to it. Okay. These people who voted in favor of it, and we're going to see this in an anti-federalist paper who made the direct complaint, voted because they were told that alterations would be made, that the alterations that they were requesting would be taken seriously. And this is exactly why James Madison is a con man. James Madison and the rest of the Federalists, because they gave the appearance that they would take these alterations seriously. They even made the first Bill of Rights, when it was first drafted, it had about 20 points to it. But then what happened was, if we look at the date that the Bill of Rights was actually made into a reality, was December 15th, 1791. That's a year and a half after Rhode Island ratified with the request of these alterations. So a year and a half later, they totally took apart the Bill of Rights. And by this time, the people who were taking apart the Bill of Rights were mostly Federalists inside of the federal Congress. If we go back to that timeline of ratification, we see in 1789 is when the Congress first began to convene. On March 4th of 1789, the Senate was made up of 11 states and would include 20 Federalists and only 2 Anti-Federalists. The House would seat 48 Federalists and only 11 Anti-Federalists. So by this time, the Anti-Federalists were totally outnumbered, and anything that they said wouldn't matter at all. And you can bet your ass, just like most senators and congressmen are bought out today, just like most senators and congressmen don't give a shit about the states that they represent, these Federalists did not give a shit about the states that they were representing. So that's pretty much what happened. Just like today, how politicians promise stuff and then they build up this great rhetoric, but then when time comes to actually have a vote, when time comes to, as Trump says, drain the swamp or to make the corrections that need to be made, those corrections are not made. And this is exactly what James Madison did. He gave the appearance during most of the part of the ratification process that a Bill of Rights, a legitimate Bill of Rights, would be put together. And not just that, but the Bill of Rights, as I was saying before, these states wanted this Bill of Rights interwoven directly into the Constitution. And James Madison actually made it as if he was going to do this. And you can find this in the article, the 5 things that Congress removed from the original Bill of Rights. And it says here, and the final big difference that Madison wanted was the entire Bill of Rights interwoven within the Constitution and not appended at the document's end. And guess what? The excuse was, that idea didn't pass muster with Congress because there were concerns of an appearance that the Constitution was being rewritten. So Madison dropped his support of interweaving the amendment during the House debate about moving his already amended Bill of Rights to the Senate. So there you go. That was like one of the last things that he gave up. He was like, oh, okay, well, I already amended the Bill of Rights so much, and I'll give up on interweaving it into the Constitution. We'll just have it like a little attachment at the end. Even though, as I said at the start of this video, trust me, this has a major impact. The fact that it's not part of the main body, the fact that they didn't interweave it into the main body of the Constitution does affect its authority. Now I'm going to move on. James Madison, obvious con man, very much like the politicians of today. And now it's time to move on to the first proposed Bill of Rights, the first proposed amendments. And it comes from this Anti-Federalist paper entitled The Address and Reasons of Dissent of the Minority of the Convention of Pennsylvania to Their Constituents, December 12th, 1787. This is 2 months after the Constitutional Convention ended and the U.S. Constitution was essentially presented. So how is it that these guys managed to come up with a legitimate Bill of Rights within 2 months, but it took James Madison 2 years to present his? So now we're going to look at the 14 amendments, or the 14 alterations, presented by the minority of the Convention of Pennsylvania to their constituents. These are 14 amendments, and you're going to see that these 14 amendments are very similar to the amendments that James Madison is credited for. So they weren't his ideas, okay? These supposed ideas that he had, they were stolen from not only these 14 amendments, but very likely from the other alterations that were presented from the other states later on. And you're also going to see that some of these amendments are actually a lot better than the amendments that were ended up on the Bill of Rights. And this is just the 14 presented here. I would love to dig up the other alterations that were presented by New York, who had 33, or these other states that had 20-something alterations. I would love to see those, because I'm sure that those are even better. But this is just the first 14 that could be picked out very easily from the first observations of the Constitution. Number 1. The right of conscience shall be held inviolable, and neither the legislative, executive, nor judicial powers of the United States shall have authority to alter, abridge, or infringe any part of the Constitution of the several states which provide for the preservation of liberty in matters of religion. Now, this sounds a lot like the First Amendment, the freedom of religion. However, it's actually better, because if we look at the First Amendment, it says, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, and so on and so forth, and then it goes into free speech. Now, if you actually look at this First Amendment, this actually pertains to established religions, While this original one, the one from the Anti-Federalists, specifically talks about the right of conscience. That's the right to think what you want. It doesn't matter whether what you're thinking is established or not. And this is actually an argument that a lot of people have made about this. Now, moving on to the second one. So, number 2, that in controversies respecting property and in suits between man and man, trial by jury shall remain as heretofore as well in the federal courts as in those of the several states. So pretty much this is saying that you should have a trial by jury in civil cases and not just criminal cases. Now this is very similar to the Second Amendment. This is very similar to the Seventh Amendment. However, the Seventh Amendment comes with certain prerequisites. So the Seventh Amendment says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This basically means that the Seventh Amendment to the United States codifies the right to a jury trial in certain civil cases. See, the thing is, not all civil cases can one get a trial by jury. And actually, if you've ever been in a civil case of your own, you'll find that it's actually very difficult to get a trial by jury for a civil case. It used to be, in the Seventh Amendment, the controversies exceeding $20, but it's actually been slightly altered. So let's move on to, and actually I just want to quickly say also that this was a big point for the Anti-Federalists, is if you read the Anti-Federalist papers, they complained that the Constitution didn't have this preservation of trial by jury for civil cases. So the third one, that in all capital and criminal prosecutions, a man has a right to demand the cause and nature of his accusation, as well in the federal courts as in those of the several states, to be heard by himself and his counsel, to be confronted with the accusers and witnesses, to call for evidence in his favor, and a speedy trial by an impartial jury of his vicinage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, and that no man be deprived of his liberty except by the law of the land or the judgment of his peers. So this is a lot like the Sixth Amendment, and it's also a lot like the Fifth Amendment. It's kind of a combination of the two. So remember, the Fifth Amendment is you have a right to not incriminate. You have a right to not self-incriminate. Or in other words, you have a right to not speak. If you plead the Fifth, you're basically saying that you're not going to talk. You refuse to talk because you feel that you talking will cause you to incriminate yourself. So the Sixth Amendment, just real quick, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And so that's very similar. So, these similarities here is just showing that the Bill of Rights was not the idea, or was not made up of the ideas of James Madison, like the article claims and like many people believe. The Bill of Rights and the amendments in the Bill of Rights were the ideas of different anti-federalist writers and different people who were opposed to the Constitution. So number 4, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel nor unusual punishment inflicted. So pretty much the same thing as the Eighth Amendment. Moving on to the number 5, that warrants unsupported by evidence were by any officer, and basically like they need a warrant and they can't just be given a warrant for anything, very much like the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So very similar. Yeah. Number 6, that the people have a right to the freedom of speech, of writing, and publishing their sentiments. Therefore, the freedom of the press shall not be restrained by any law of the United States. So that's pretty much like what is found in the First Amendment, the freedom of speech and freedom of the press. So number 7, that the people have a right to bear arms for the defense of themselves. And actually, so number 7 is the Second Amendment, but it is a much better version of the Second Amendment. Here's number 7. that the people have a right to bear arms for the defense of themselves and their own state, or the United States, or for the purpose of killing game. And no law shall be passed for disarming the people or any of them, unless for crimes committed, or real danger of public injury from individuals. And as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up. And the military shall be kept under strict subordination to and be governed by the civil powers. So as you can see, that's a much better version of the Second Amendment. It's actually clearly stating, okay, let's look at the Second Amendment real quick, okay? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, that's very ambiguous. Okay, that's like, okay, well, do these people that are keeping and bearing arms, do they have to be part of this well-regulated militia? Very ambiguous. Compared to this one, straightforward. The people have a right to bear arms for the defense of themselves and their own state, or the United States, or for the purpose of killing game. And no law shall be passed, okay, etc. And the best part about this one is it talks about standing armies. It gave a clear point that a standing army in the time of peace are dangerous to liberty. They ought not to be kept up. This would be saving the American people tons of money. Okay, we wouldn't have had put so much money into a standing army in times of peace. So moving on. Oh, and by the way, this is also, before I move on, the whole and the military shall be kept under strict subordination to and be governed by the civil powers. I feel like you can stretch that to covering the Third Amendment, which is an amendment that is all right, but I don't really like. No soldier shall, in time of peace, be quartered at any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. See, I mean, this doesn't really make any sense. That kind of means that, like, in a time of war, a soldier can be kept or quartered in any house, so long as the law has prescribed it. It's very weird. I don't like that amendment. I mean, it makes sense. I understand where it comes from, and it's at least it's there. But it's just kind of like, I don't know, man. It kind of opens up the door to say that, oh, actually, you can be forced to quarter a soldier in a time of war, so long as there is a law that is created to allow such a thing. This is, if anything, this amendment gives the Congress and the president and the Supreme Court power to pass a law and approve of a law that allows soldiers to be quartered in your home during times of war. So number 8. And I actually really like this one. I really like number 8. The inhabitants of the several states shall have liberty to fowl and hunt in seasonable times, on the lands they hold, and on all other lands in the United States, not enclosed, and in like manner to fish in all navigable waters, and others not private property, without being restrained therein by any laws to be passed by the legislature of the United States. I really like this law. I mean, I think it's very reasonable that private citizens should be allowed to fish. They shouldn't have to go and get a fishing license, nor should they have to go get a hunting license. If it is a season, if it's hunting season, they should be allowed to hunt specific game, and they should be allowed to fish in waters. I think that people should have the rights to obtain their means of eating. Okay, it's messed up. I mean, that you have to force somebody to get a license to do things that would otherwise be necessary to sustain their life. So they should be allowed to obtain their food. Same thing with planting food also. They should be allowed to plant vegetable gardens. So number 9. And number 9 is another excellent one. And the funny thing though is number 9 is actually incorrectly put online. I got this screenshot from the internet. And fortunately I have a book that has the correct version of number 9. But I'll read what's online, and then you're going to see the difference. Number 9, that no law shall be passed to restrain the legislators of the several states from enacting laws for imposing taxes, except impost and duties upon goods imported or exported, and postage on letters shall be levied by the authority of Congress. See, this is actually incomplete. And you can tell that this is wrong just because of what happens at the end here. It doesn't make any sense. Except impost and duties upon goods imported or exported, and postage on letters shall be levied by the authority of Congress. It seems like, it's saying that this is all Congress can do, but there's actually a more correct version of this. And it's funny too, because the Federalist paper that these screenshots are taken from the internet, every single one of them is exactly how they are in this book, the Essential Federalist and Anti-Federalist papers. Every single one of them is correct, except for this one, and I find this very odd. So on page 9 of this book, you have this list, and at the very bottom, we have the correct version of this. And the part that's missing is that no taxes except imposts and duties upon goods imported and exported and postages on letters shall be levied by the authority of Congress. That is why I love this one, because it is actually limiting the power of taxation that Congress has. Right now, without this amendment or without this clause, Congress has a virtually unlimited power of taxation. All they have to do is say it's for the public good, and they can pretty much say that to anything they want. So this one is actually awesome. It actually limited that unlimited power that Congress has on taxation, that allows Congress to tax your income, tax your property. I mean, all of these things. It's just wrong. So this is actually a big point that the Anti-Federalists made. They were actually they were actually heavily against direct taxation. They didn't believe that it was right for one to have a direct tax on somebody. They believe that all taxes should be indirect taxes that a person can basically voluntarily pay, such as the impost on duties upon goods imported and exported. If you want to get into that import and export business, then you can pay taxes. If you want to have a postage on letters, then you can pay a tax for that. You can deliver your own. See, the thing is, you can deliver your own letters and not have to pay that tax. You can go and instead of importing or exporting things, you can just produce your own things. You can fish yourself. You can go hunt game yourself. You can make your own things and not have to worry about dealing with those taxes. So those taxes are indirect taxes. They were entirely against direct taxes such as income tax and property tax. So moving on to number 10. That the House of Representatives be properly increased in number, that the elections shall remain free, that the several states shall have power to regulate the elections for senators and representatives, without being controlled either directly or indirectly by any interference on the part of the Congress, and that elections of representatives be annual. This was another very important thing. They believed that representatives should be changed every single year. Not this 2-year or 4-year or 6-year bullshit. They believed that the representatives should be changed annually. And they made a lot of great arguments how this is the best way to fight corruption. So, moving on to number 11. That the power of organizing, army, and disciplining the militia, the manner of disciplining the militia to be prescribed by Congress, remain with the individual states, and that Congress shall not have authority to call or march any of the militia out of their own state without the consent of such state, and for such length of time only as such state shall agree. This was very important because actually, believe it or not, right now Congress has a virtually unlimited power over the militia, and the Anti-Federalists found this to be deplorable because they said that, well, now the Congress can march a militia out of one state to basically quarrel or squash a rebellion, a just rebellion in another state. And then it goes on to say that the sovereignty, freedom, and independence and independency of the several states shall be retained, and every power, jurisdiction, and right which is not by this Constitution expressly delegated to the United States and Congress assembled. So basically, this is like the 10th Amendment, I believe. It's like the power not delegated to the states shall remain in the power not delegated to the United States Congress or to the federal government shall remain with the people in the states or whatever. So here goes the militia clause to show that Congress has this power. Moving on to number 12, that the legislative, executive, and judicial powers be kept separate, and to this end that a constitutional council be appointed to advise and assist the president, who shall be responsible for the advice they give. Hereby, the senators would be relieved from almost constant attendance, and also that the judges be made completely independent. Another very important point. The fact that the judges are presented by the executive is actually makes them not independent, because then one party can present the judges of their preference and then have an uneven balance in the courts. This one, judges being completely independent, would probably make it so that judges would have to be elected by the people. And another thing is that the former part of this amendment is very important to keep presidents from waging wars on the behest of Congress. And surprising or not, this is actually something that Madison also wanted. So Madison also wanted to clearly spell out that each branch of government had clear, distinct roles. But it ended up not really getting it into the thing. So now this next one is actually just as important. It's actually related to number 12. That no treaty which shall be directly opposed to the existing laws of the United States in Congress assembled shall be valid until such laws shall be repealed or made conformable to such treaty. Neither shall any treaties be valid which are in contradiction to the Constitution of the United States or the constitutions of the several states. This one was super important, and this is actually a huge point that the Anti-Federalists made. The point that they were making was that because the president has the power to enter treaties, they can pretty much totally usurp the Constitution. They can enter a treaty that will basically totally bypass the laws of the Constitution. And this is exactly what happened when we entered a NATO treaty and when we entered the UN treaty. And that's why in 2011, our military was allowed to bomb Libya without the approval of Congress, because Obama said, oh, well, this is a NATO-led coalition, so, the United States is bombing for NATO. So this one's very important, and it would have cleared up a lot of problems that we've dealt with, and it's just another thing that the Anti-Federalists got right. They said, hey, look, their power to enter treaties is going to lead to such tyrannical acts, it's going to lead to them bypassing the Constitution, and that's exactly what happened. And if you read the Anti-Federalist papers, you'll see that every single thing the Anti-Federalists predicted has either come true or is in the process of coming true. So number 14, that the judiciary power of the United States shall be confined to cases affecting ambassadors, other public ministers, and consuls, to cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of different states, between citizens claiming land under grants of different states, and between a state or the citizen thereof and foreign states, and in criminal cases, to such only as are expressly enumerated in the Constitution, and that the United States in Congress assembled shall not have power to enact laws which shall alter the laws of descent and distribution of the effects of deceased persons, the titles of lands or goods, or the regulation of contracts in the individual states. This one is also very important because it actually put a restriction on the Supreme Court. As of right now, the Supreme Court has incredible power, virtually unlimited power, and this is an argument that the Anti-Federalists made in a lot of their papers. But this one was necessary to say, hey, look, this is what the Supreme Court should be allowed to do, and everything else the Supreme Court shouldn't be allowed to do. It's none of their business. So this was also very important. So now moving on. That's the 14 that are expressed 2 months after the Constitution is presented. We need to remember that there were 33 presented by New York, and that there were 26 or something like that presented by Massachusetts, and other states also presented alterations/amendments. And not only do I believe that the actions of James Madison are deplorable, but I also think that it's deplorable and pathetic that public schools do not teach these other amendments, do not show people that, hey, look, there were other alterations that could have been made to the United States, that could have been made to the Constitution, that would have been incredibly beneficial, especially in hindsight from today. We see the treaties that are used, we see the Supreme Court decisions, we see many of these things. We see fishing licenses, we see attacks on the Second Amendment, we see a standing army. We see the freedom of religion is bullshit because it's not a freedom of religion, it's a freedom of established religion. So there are a lot of alterations that would have been incredibly beneficial, and I think that people should be exposed to them. People should be exposed to these other alterations, and maybe if they were exposed to these other alterations, they would want to put these other alterations or amend these alterations or amend the Constitution with these alterations today.